Hi, very good morning. This is a Delhi High Court judgment. Gaurav Jain versus Joint Commissioner Appeals. Interesting judgment, but seems to be based on settled principles of law. Issue is in case of penalty only orders. That means there is no tax, interest, or any other demand in that order. Only penalty is there. Penalty only orders. Initially, there was no pre-deposit required for filing an appeal against that order. Subsequently, on 1/10/2025, a proviso was introduced stating that 10% pre-deposit has to be made for filing an appeal against the penalty only order. Now, the issue before the Delhi High Court was whether this penalty provision, the provision requiring pre-deposit of penalty, 10% of penalty, whether it is prospective or retrospective, whether it applies to the proceedings initiated prior to the introduction of the provision. That was the issue before the Delhi High Court. So in this case, show cause notice was issued prior to the introduction of this proviso. For the benefit of the tax people, 1076, the proviso, 1076, the entire section I am reading. The section says, no appeal shall be filed under subsection 1 unless the appellant has paid A. I am not going to read the entire thing. So admitted tax you have to pay. That is the clause A. B says 10% of the disputed amount has to be paid of the tax. Suppose if you have 100 rupees tax dispute, whatever admitted tax as per return you have to pay. Whatever disputed tax you have to pay 10%. That was the initial thing that was there. On 1/10/2025, a proviso was introduced. That proviso reads as below: provided that in case of any order demanding penalty without involving demand of any tax, no appeal shall be filed against such orders unless a sum equal to 10% of the said penalty has been paid by the appellant. This proviso earlier, it was prior to 1/10/2025, it was not there. So it says 10% of the penalty has to be paid in case of penalty only orders for entertaining the appeal. Now, the petitioner, there is a huge demand of penalty. I am really surprised. Individuals, whether they can have that much penalty. 346 crores of penalty was imposed because he was involved in some fictitious transactions, passing on the input tax credit. So 346 crores penalty was imposed. That is mind-boggling yet spending. But in this case, the show cause notice was issued prior to 1/10/2025. That is prior to the introduction of the provision. But order was passed subsequent to that. So he filed an appeal against that order. He moved an application for a waiver of pre-deposit. But the appellate authority said nothing doing. I am sorry, my hands are tied. You have to pay 10% of penalty. Otherwise, I will not hear the appeal. So he rejected. On this, they filed a writ petition before the Delhi High Court. Delhi High Court repeated the settled principles of law. These are all settled principles of law in tax. Any person who is dealing with tax, they may be knowing all these things. In any case, I am repeating it. Right of appeal is a creature of statute. Legislature, which creates the right, may impose conditions governing such right. It is firmly established that the right of appeal is substantive and not procedural. Once vested, it cannot be taken away, impaired, or subjected to more onerous conditions unless important, legislature has shown that intention expressly or by necessary implication. Although an appeal can ordinarily be filed only after an adverse order is passed, the right to pursue the appellate proceedings attaches to the commencement of LIS. The adverse order merely makes the right capable of exercise. So now the question is, in this case, when the list commenced? Is it after passing of the order, that is after 110/2025, or is it before the passing of the order, when the show cause notice was issued? So the Delhi High Court said the relevant date is the date on which the list commences, that is the date of show cause notice. No dispute. On date of show cause notice, whatever is the appellate package is there, that will govern the appellate proceedings. Finish. You don't have to see anything else. When the show cause notice is issued, that is the date that will govern what is the appellate proceedings that will govern this person, the appellant. Whether there is an, then the next question arises. Already I said, unless there is an intention to apply this retrospectively. So, whether there is an intention to apply the new condition to pending proceedings or not, that was the issue. So, Delhi High Court said that neither Section 129 of Finance Act 2025 nor the substituted proviso states that the new proviso shall apply to pending adjudicatory proceedings. Nor is there a transitional provision identifying pending proceedings which should be governed by the earlier or substituted regime. So then the department argued, no, kindly, my lord, please see, no appeal shall be filed. That is a word which is the words, no appeal shall be filed is there. So that must be construed that every appeal filed after 110/25, that must satisfy the condition of pre-deposit. Delhi High Court rejected this contention. It said these words only determine the stage at which the compliance is required by the appellant. They do not answer the question which appellate regime will govern the proceedings initiated before the substitution of the proviso. It only says, no, at the date of filing the appeal, you have to pay 10%. That is what it says. It is not deciding which appellate package will govern the proceedings. Then they said, no, the new provision always replaces, the department said, replaces the old one. Court agreed with that. There is no dispute on that. Whenever a new provision is introduced, it replaces the old one. There is no doubt. However, that does not by itself divest the vested rights which are already accrued under the earlier law. Where an amendment is not retrospective, rights and obligations crystallized upon commencement of the list remain unaffected unless the Amendment Act expressly or by necessary implication provides otherwise. A legislative intention to impair a vested right, it cannot be inferred merely because the amendment is expressed in general terms. Necessary intendment requires something in the language, scheme, or operation of the enactment which is inconsistent with the continuance of the existing right. So in this case, no such inconsistency is discernible. That is what the Delhi High Court said. Then the department said, no, my lord, please kindly see section 107(7). It grants automatic stay on payment of 10% of penalty. So you must construe in that case that 107(6) governs even the proceedings initiated prior to 110/25. This contention was also rejected. Delhi High Court said it merely prescribes the consequence that follows upon the compliance of deposit. It cannot be employed in reverse to determine which version of section 107(6) determines the appellate right. I am sorry. It said just because you grant automatic stay, that does not mean that will apply to the previous proceedings, previously initiated proceedings. Then the other contention of the department was this provision itself was introduced for discouraging frivolous appeals, because people just like that they are filing appeals. So 10% if they pay, they will be sincere in pursuing it. That is what the contention was. Then this contention was also rejected by the High Court. It said it cannot supply retrospective operation which the language does not contain. Consequence cannot justify imposing a burden upon a vested appellate right. That is what the court said. Then the other argument which advanced by the department was, see, the petitions themselves ask for waiver or reduction of pre-deposit. So hence, that means their understanding is also that it will apply. That is the argument. So High Court said that will not determine the statutory regime applicable to their appeals. An erroneous assumption of law made by a litigant, it cannot render applicable a statutory provision which otherwise does not govern the proceedings. Nor can there be an estoppel against the correct interpretation of statute. No, no, no. Just because they ask for waiver, you cannot say no, no, that will apply. It is an erroneous assumption of law, and there is no estoppel against the interpretation of law. Then finally, Delhi High Court said, Finance Act 2025 neither expressly nor impliedly subjects adjudicatory proceedings initiated prior to 11025 to newly introduced 10% deposit in penalty allowed cases. So they need not have to pay. Substituted proviso does not govern the appeals arising from show cause notice prior to 11025. That is what the court says. So the court ordered the appellate authority to admit the appeal and hear it on merits without payment of 10% of pre-deposit. Definitely, it is uh, uh, at least for these guys, because they have a penalty to the extent of 346 crores. So 10% means 34 crores they have to pay. So a great relief for the petitioners as far as they are concerned, at least. But let us wait and see whether the government again amends it and says, no, no, this provision intended to be uh, uh, applied for the pending proceedings also. Maybe another amendment they will introduce to the pending proceedings. Let us wait and see. Thank you very much. Have a great and wonderful day. Bye.